All right, good morning, everybody. It's now 9:07 a.m. and I will call to order the first meeting of the Act 156 Task Force on Parentage Laws. My name is Lauren Chun. I'm a Deputy Solicitor General with the Department of the Attorney General for the state of Hawaii, and I will be the chair of the task force. Now, as we probably all know, this task force was established pursuant to Act 156 of 2023, and its task is to recommend amendments to the Hawaii Revised Statutes to update existing parentage laws that reflect outdated concepts of families, parenthood, conception and gestation, and parental rights. So before we begin, I want to let any members of the public know, if they are watching on Zoom, that they will have the opportunity to present oral testimony during the meeting if they wish. What will happen is that after the task force has had their discussion on any of the agenda items, and before taking a public vote, I will, or moving on to the next item, I will ask if there are any members of the public who want to present testimony. If they do, I will, let them speak. They can use the raise hand function on Zoom, and IT can promote them to a speaker so we can all see and hear them. And I will ask any members of the public who want to testify that they keep their testimony limited to 3 minutes. No, I'm sorry, okay, so Lauren Kim has asked for the Zoom link, so I hope, I'm just gonna have someone send her the link. Okay. All right, so first I'll just do a quick roll call of the members of the task force who have already been appointed. When I call your name, please say here. Also pursuant to HRS 92-3.7A. If you are one of the task force members who are appearing by Zoom, please identify the name of any person with you in the room who is 18 years or older, or anyone under the age of 18 who might have a business or financial interest in today's meeting. Again, if you're alone in the room, you don't have to disclose anyone, obviously. So I will go through the role as listed in Act 156. So I'm here. Next person would be Lauren Kim from the Department of Health. I think she might be trying to. Oh, sorry. I'm sorry. I think he might still be trying to log in. Okay, so we'll skip him for now. Thaddeus Pham. I see that he's here.
I'm here and I'm alone.
Thank you. Jeff Esmond.
Yes, I'm here. I'm alone.
Thank you. Judge Jesse Hall.
I'm here and I'm alone.
Thank you. Carol Lockwood.
I'm here, I'm not alone.
Dr. John Fratarelli.
I'm here, I'm alone.
All right, thank you. Dr. Cheryl Andaya.
I'm here and I'm alone.
Thank you. Ms. Laurel Johnson.
Yes, I'm here in the room.
Is Sean Taylor present? I don't see him here. And then there's also a member of the task force must be a member of the Commission on the Status of Women, and I have not received their appointee yet. So that position is currently vacant. So okay, so we do have a quorum, and we can continue with the meeting. So moving on to item B, this would be an introduction of the task force members. So I think, as you all know, Act 156 requires that people with certain qualifications and backgrounds be appointed to this task force. And because this is our first meeting, I'd like to start by having the folks who have already been appointed to introduce themselves to the group. And just so we know, there are some other folks who who we will vote on to be included in the task force, and I'll have them introduce themselves later. But for now, I'll go through the folks who have already, indicated that they're present. So I'd like to have you, just introduce yourselves, share a little bit about your background, your interest in the task force, and what you hope to bring or contribute, and anything else that you would like the group to know about you. So I'll start out, and then I will call on people to introduce themselves in the order that their roles are listed in Act 156. So again, I'm Lauren Chan. I'm a Deputy Solicitor General in the Appellate Division of the Department of Attorney General. Act 156 required that our department appoint a representative who would serve as the chairperson of the task force. So that has been me. And I have to say, I don't really have much experience in this area of law at all. But, in my role as a Deputy Solicitor General, I do have to, kind of quickly learn a lot about different areas of law. So I'm hoping that I can bring that experience to this task force. I've also, before I joined as a Deputy Solicitor General, I was in the Land Division of the department. And in that capacity, I did advise several sunshine boards and commissions, such as the Board of Land and Natural Resources and the Commission on Water Resource Management. So I do have some experience with, advising boards and commissions and complying with sunshine law. And I really hope to bring that experience to this task force. And I think what I see my role here as is, making sure that we produce a work product that we're all proud of, that our department can be proud of, that will be helpful for the legislature, and to make sure that we are all on track and taking our role seriously. So yeah, that's what I hope to bring, and I'm excited to be working with you all. And I think that I saw Sean Taylor join. Sean, are you present? Maybe he logged off again.
Let's scroll up and scroll down to show which one squares, or are those all the squares? Oh, he said he just joined. He can't hear anything.
Oh,
Oh dear.
I texted him.
okay.
Yeah.
Okay, I see that he's present. So he won't be. Okay. Well, as soon as he
I'll tell him to try like Wi-Fi. Whatever he
Yeah.
select. Did you select?
if he can't hear us, it might be an issue on his end, because it seems like
Everybody.
the
else.
other members can
Anyone
hear.
else can hear?
Okay, well, we will hopefully get Sean to log in. For now, I will ask the next person listed in Act 156 to introduce themselves. So the next person would be the Director of Health or the Director's designee. And actually, the Director of Health has appointed 2 people to represent them. And I think right now only Thaddeus is in the meeting. So Thaddeus, could I have you introduce yourself, please?
Sure. Thanks, Lauren, and good morning, everybody. So my name is Thaddeus Pham, he, him. I'm with the Department of Health, and I convene and co-chair the Hawaii's Sexual and Gender Minority Work Group. I was involved in the previous task force for Act, what was it? Act 201. So I'm excited to be back with you all. And I just give you, I guess, a little bit of a background similar to Lauren. My expertise is not in law, but I do convene and hear from our community stakeholders. So this is an issue that was brought forth by them in terms of equitable parentage for same-sex and non-gestating couples. So thank you so much for the opportunity to represent the Department of Health today.
Okay, thank you, Thaddeus.
Sean can hear now.
Okay.
You saw him a second ago.
All right,
Oh,
Sean,
sorry, Lauren, real quick. I just also wanted to know, I'm so sorry. I will have to leave at 9:30 for another thing. So apologies to
Okay.
everyone for that.
all right, thank you. Okay, oh, that's Lauren.
Oh, weird, we can't see.
Okay, well, now that Lauren Kim has joined, Lauren, I don't know if you were able to hear my introduction, but I'm just giving the members of the task force an opportunity to introduce themselves. Since you just joined, I'll come back to you, and I'll have you introduce yourself at that time. All right, so again, the next person listed in the act would be a member of the Hawaii State Commission on the Status of Women. Again, I haven't received their designee yet, so that position is currently vacant. The next member is a member of the Hawaii State Commission on Fatherhood, and in that role we have Jeff Esmond. Jeff, would you be able to introduce yourself, please?
Sure. Hi, good morning, everybody. Jeff Esmond, and I'm representing the Hawaii State Commission on Fatherhood as the current chair of the commission right now. And the Commission on Fatherhood generally has the objective of supporting fathers' involvement with their children. My understanding of one of the reasons that it was created, I think about 20 years ago, was to due to a lot of absentee father situations, and to really just bring the father around for the benefit of the child. I was appointed or nominated somewhat out of the blue 2 years ago. I guess the governor, Ige, was looking for someone from the LGBT community and to represent on the Commission on Fatherhood. And so someone who knew me, and because I had been slightly involved with Equality Hawaii and the marriage equality movement back a number of years and have children. So my name got forwarded, and over the past 2 years, somewhat due to lack of ability of other commissioners, I found myself as chair, and I'm involved in something that I have so little background with. I do want to talk a little bit about my personal background, which may be relevant. That my husband and I were looking to have children through surrogacy, and around 2006, 2007, we could not figure out how to do it in the United States or even in Hawaii. We had been turned down here in the state of Hawaii to do it, so we ended up turning to international surrogacy, and we ended up traveling to India, where at the time surrogacy was a huge industry, and it wasn't easy. It took multiple trips, but ultimately, between the years of 2000 and 2012, we ended up with 2 successful pregnancies. We have 3 children. We have twins who are 13 in middle school and a 10-year-old in 5th grade, and we're loving being fathers, if I can just say that. So I don't really have legal experiences. I have the experience of the co-parent adoption process way back then, as well as our own fears during the process of what would happen to our children if something happened to the one who was the biological father at the time, because it was a long process to get the other one on as co-parent. So that's a bit of background on me. Thanks.
Thank you very much, Mr. Esmond. Thanks for sharing that with us. So the next member of the task force is a family court judge, and our appointee is Judge Jesse Hall. Judge Hall, could you introduce yourself, please?
Sure. Good morning, everybody. I'm Jessie Hall. I am a judge with the family court here on the island of Oahu in the First Circuit. I also am currently the lead judge of what we call our special division, which does include all paternity cases. I was also on the original Act 201 task force. I'm also the one that drafted the initial draft of the UPA that we've been working off of, both in Act 201 as well as the current version that brought us here today. I hope to bring to this the more of the legal side as well as the procedural side. We have, as Mr. Esmond mentioned, we have had to create workarounds to deal with surrogacy cases, and so I'm able to provide that information. Thank you.
Thank you very much. Right, our next member is a family law attorney, and our appointee is Ms. Carol Lockwood. Carol, could you introduce yourself, please?
Sure. Can you all hear me online? Okay. My name is Carol Lockwood. I am a family law attorney here in Hawaii. Back in around 2009, when the economy slowed down, I went to do some pro bono adoption work for the Legal Aid Society and started getting asked to do a lot of adoptions, much to my delight, and then started getting asked if I could help with surrogacy. And so it's been about 14 years. I'm Hawaii's only member of the Academy of Assisted Reproductive Technology Attorneys and the Academy of Adoption Attorneys. I've done, I'd imagine, somewhere around 200 assisted reproductive technology cases, surrogacy, embryo donation, sperm donation, ovo donation. As Judge Hall said, we have to kind of invent a framework and operate within our existing laws and find what is applicable by analogy, as opposed to having laws that are directly on point. And we do run into roadblocks or unnecessarily delays, as Mr. Edmond mentioned. So I'm very interested in seeing what we can do to help the state follow in the footsteps of some of the other states that have put into place some very effective processes and procedures to facilitate and also provide safeguards for these things. And I should mention that I'm a customer because I had both of my sons through donor insemination. They are now, one's about to turn 18, much to my shock, and one will be 15 in January, but I had them both through donor insemination, which is part of what fueled my interest. I think it's an incredible blessing, especially in a state where Ohana is so important, that people are able to build families in so many ways and experience, as once again, Mr. Edmond mentioned, the joy of parenthood.
Okay, thank you, Carol. All right, our next member is a healthcare professional familiar with hospital and birthing center procedure experience. And our appointee in that role is Dr. John Fratarelli. Doctor, could you introduce yourself, please?
Yes, hi, I'm John Fratarelli. I'm the founder and director for the Fertility Institute of Hawaii, which was founded in 2011. Since then, we've helped hundreds of patients who are single, heterosexual, and same-sex build their families using donors and surrogates. I also have a personal interest. I did use a surrogate myself, so I understand that for my last child 5 years ago, so I understand the medical and the personal side of those who need to use the surrogates process.
Thank you, Doctor. So our next member of the task force is a mental health professional familiar with post-adoption experience. Our appointee in that role is Dr. Cheryl Andaya. Dr. Andaya, could you please introduce yourself?
Hi, good morning, everyone. Cheryl Andaya, she, her pronouns. I'm a licensed clinical psychologist. I'm also the director for the Family Strengthening Center. So my background is basically working with children and families, particularly those who are involved with child welfare services. But I have also worked with families in private practice, dealing with child maltreatment and providing more of a trauma-informed approach to the services we provide. So I do have experience in consultative services, psychological evaluations, as well as therapy for children and their families. And usually the families can consist of various individuals, grandmas, grandpas, resource caregivers who want to adopt the child they're fostering.
Thank you, Dr. Andaya. Our next member is an individual with personal knowledge of adoption-related health and medical issues. And our appointee in that role is Ms. Laurel Johnston. Laurel, could you introduce yourself?
Yes, thanks. Good morning. Aloha, everyone. I am an adoptee who was raised in a closed adoption system from birth. I did reunite with my birth mother when I was 33 and was in a relationship with her until she died in 2009. So that has driven my work. I've been involved in opening sealed adoption records, both in Hawaii and other states. And I'm basically an advocate for persons who are raised within a system that deny them access to their birth heritage or their health and genetic information. I really think that unfortunately, the child's position in all this sometimes gets overlooked or lost. I also want to disclose, because I'm adopted, people sometimes think I am not supportive of women's choice. I'm a pro-choice advocate. And for the LGBTQ community, I was an ally back in 1997. I was the staff director for the Senate Judiciary Committee when we first tried to pass, and unfortunately did not succeed in passing same-gender marriage. So I've been with the community for a very long time now. I appreciate that this has become very difficult because we now can create families in many different ways. But I'm really, really concerned based on my own experience and that of many, many people who were denied access and still don't have access to their medical information, their genetic heritage, and healthcare information. And actually, current adoption laws in Hawaii, which I helped work on, actually allow that in adoption. So I really wish we would look first at what is currently in Hawaii law before we start using laws from other states or other communities. I would also note that Hanai is really important in Hawaii, and we've been doing Hanai in Hawaii for decades, centuries. And Hanai basically is based on people knowing each other and family members knowing each other. So I think we have a strong history here in Hawaii. And so I would really prefer that we look to Hawaii first before we look at a uniform law and try to craft something that can work for everybody, and particularly the children. Thank you for your consideration of my comments.
Thank you, Ms. Johnston. Our next appointee is an individual with personal knowledge of surrogacy. In that role, we have Sean Taylor. Sean, I think, yes, I see you there. And since you weren't here for the roll call, Sean, since you're appearing by Zoom, just if you're alone in the room, just note that it's fine. If there are other people with you over 18, then you just have to identify them. Yeah, please introduce yourself, Sean, and let us know if you're accompanied by anyone.
I'm alone. But I feel like I'm there with you guys now. Sorry, I was having technical difficulties earlier getting on and had to switch to my phone. I'm a dad. My husband and I have two kids, 6 and 3, which I'll blame them for the scatterbrained and sort of approach to this morning for me. So I'm a lawyer, but I'm here. I think I was invited because of personal experience. I've got both of my kids, my husband and I had through surrogacy, through a surrogate. And Carol Lockwood's in the room. She was our attorney on one of them. Yeah, I think, and Dr. Frederelli, one of his colleagues, was the doctor that helped us with this. It's a small community. I know several of the people in this call. I don't have a speech or anything. I don't have an agenda here. I have been involved in some advocacy. It's getting a little dated. I was on the last iteration of this group, and I've been involved in some advocacy around same-sex marriage and other family-related issues over the years. But I'm looking forward to having a good conversation and helping any way I can.
Great, thank you very much. I will bring this back to Mr. Lauren Kim, I don't think he was here originally when we took roll. So again, Lord, if there's anyone in the room with you, just note that. And after that, please introduce yourself to the group.
Good morning, everybody. Lauren Kim. I'm by myself in the Maui Seaside Hotel. I will be on the call for, I think it's duration, but I will have to shut off my video at some points because I have to get to the Lahaina Disaster Recovery Center for some wildfire recovery work, but I will be on. I just don't want to have you see me walking across parking lots. At some point, I will have a colleague in the car with me, but I'll be on headset. So thank you for the opportunity to be here. The Department of Health was the convener of the first working group that met during the pandemic. And we quickly, well, not quickly, over time, we realized that we were out of our depth. I think the report that was submitted on behalf of the task force laid out some key issues, many of which I've heard already from the speakers who have introduced themselves. But it got to the point where we needed to amend subsection by subsection, and that is not the Department of Health strength. So we're grateful for our Attorney General partners to actually make this happen. One commentary I'll make is the measure that originally set this in motion was extremely narrow. If you had the ability to conceive biologically, then the original proposal worked for you, but it shut everybody out, and that was not acceptable to the Department of Health. And as expressed in testimony and subsequent drafts of the bill that led to this working group, was not acceptable to the legislature. So we wanted a fix-it for all families. And I've heard many comments this morning about there's many different kinds of families, and we want to be as accommodating and fair to everyone as possible. I was surprised to hear that surrogacy is not expressly authorized in statute. So there are many opportunities for this group, and I think we're going to do great work. And please count on the Department of Health to be there advocating for everybody's families. Thank you.
Great, thank you very much. I'll ask IT, is there anyone who has raised their hand or wanted to give public testimony on this item?
Hi, Chair. There's no attendees.
Okay, thank you. All right, so with that,
Lauren.
yes. Oh, I'm sorry. Yes. Could you please introduce yourself and if you want to present testimony, please keep it to 3 minutes.
Certainly.
Sure.
They can see us.
Yes.
Yeah, well, sort of.
Yeah, we're small.
Maybe you wanna,
If you
we're
wanna
the
go
middle
closer, you can.
screen there.
Where?
Top middle.
The top middle.
So we're kind
Where
of
the
far.
green
Yeah,
is.
if you want to go closer, you can.
Yeah, if you wanna move closer.
Yes, I will.
Yeah, sure.
I know. Looks like a long hallway.
You can see. Oh,
There you are.
Okay,
See,
I
there you
see.
go.
And to be clear, you're testifying on the item, the introduction of the task force members?
mhm.
Okay. I'll keep track of
Question,
time.
I need to verify. Are you asking me to testify on behalf of the composure of the task force members?
Well, just what you've heard, the introduction of everyone. If there's anything you wanted to comment on, you can do that now. Otherwise, if it's on a different topic, I would ask that you reserve comments until we reach that topic.
All right, that's fine.
So do you want to wait till we reach the topic you wanted to discuss?
That's fine.
Okay. Do you know what agenda item that would have been?
No, I'm
Here,
not
here's-
certain.
Okay. Yeah, I can.
I received something about 156.
Yeah, so I can, here's the agenda for today. If you want to let me know which of the items you want to testify on, we can when we get to that.
Items, the action items.
Yeah, so there's like B1 or sorry, we moved past B. There's like C1, D1, D2, D3.
Okay. D, I think.
Okay. All right, when we get to the D items, I'll ask for public testimony.
That's fine.
All right, so hearing no other requests to testify, I'll move on to item C1, this is the recommendation and approval of additional task force members. So under Act 156, Section 1B11, the task force does get to appoint any other members that they would like. And so we have four prospective members, and like we did with the members who have already been appointed, I'll ask them to introduce themselves. There can be a time for public comment on each of the prospective appointees, and then we'll vote on whether to appoint them or not. So our first prospective appointee is Mark Nugent. He is with the Department of Attorney General Child Support Enforcement Agency. And Mark, I'll have you introduce yourself.
Hi, everyone. So as Lauren said, my name's Mark Nugent. I'm with the Attorney General's office. I work with Child Support Enforcement. Specifically, I'm the branch manager of the Oahu Family Support Branch. And what that is it's a office of 5 attorneys, which includes me, as well as a small support staff. And what we're primarily responsible for is the judicial establishment of paternity. So going into court and establishing paternity and child support, as well as the enforcement and collection of child support and past due child support. So in general, that's what our office does, and I have oversight of that office. I'm involved as well in the day-to-day activities, so I do appear in court. I'm involved directly with paternity establishments. I meet regularly with parents or parties who want to be added to birth certificates. So the work that I'm involved in and my office involved in is directly related to the work that we'll be discussing in our committee. I think for me, I look for when I listen to everybody, it sounds like we have a diverse background of folks on the committee, which I think is what we need. And I just look forward to hopefully working collaboratively with everybody. I really like what Laurel said. I think she said that we want to draft something that works for everyone and benefits the kids or the keiki of Hawaii. Yeah, so thank you.
Are there any questions or comments for Mark from the task force? All right. Are there any people who wanted to offer public testimony on this item? All right, I don't hear anything from Brandon. So does anyone want to make a motion to admit or to add Mark as a member of the task force?
So moved.
All right.
Second.
All right, can we get a vote? All those in favor, can you please raise your hand? Okay. Well, I'll raise my hand. 1, 2, 3, 4, 5, 6, 7. Okay, that is a pass. All right, so Mark, you'll be added to the task force. Our next prospective member is Geraldine Hasegawa. Geraldine, can you hear us, and can you please introduce yourself?
She muted. I think.
Oh,
She does see her mute.
Unmute.
Geraldine, I think you're muted. I'm sorry.
Can
Okay.
you hear me now?
Yes, yes, we can hear you.
Hi, good morning, everyone. My name is Jerry Hasegawa. I'm a Deputy Attorney General with the State of Hawaii Child Support Enforcement Agency, and I am the branch manager for the island of Hawaii. I oversee the establishment of paternity support, enforcement of support, modification, and we deal with cases on the local level, on the national level, and also international level. I have been involved in the child support area associated with the Child Support Enforcement Agency for over 40 years. I have seen the development of the expedited process of paternity that was in 1996, the PORORA, which is the Personal Responsibility and Opportunity Act. Rosemary McShane, a fellow Deputy Attorney General who's since retired, and I have been doing the development and with the Department of Health staff and the training for this expedited process of paternity. We do have some concerns, and we'd like to express those concerns as the situation arises. Currently, Mark Nugent and I are working with Department of Health staff to update the work on the expedited process of paternity. That is our manuals, our forms, the materials for this expedited process of paternity. With regard to judicial proceedings, the Child Support Enforcement Agency would like to make sure that the issue of service is clarified. Also, personal jurisdiction be expanded to include the long-arm jurisdiction outlined in Hawaii Revised Statute Section 576B-201. With regard to genetic testing, it is very often used whenever paternity is disputed, and we would support that the genetic testing language proposed in the 2017 version of the Uniform Parentage Act be included in the proposed legislation. And lastly, with regard to the creation of 3 parents when establishing parentage, we recommend that it be limited to the situation where you have 2 alleged fathers who are identical twins. I have talked to Dr. George Maha, who is with Laboratory Corporation of America, and who has been instrumental in the development of the Uniform Parentage Act genetic testing section. And he's indicated that science is in a situation right now where it is developing, trying to address a situation where you have identical twins as alleged fathers, but it is still not quite established. So to that extent, if you do have identical twins as alleged fathers, you may have to consider having 3 parents involved in the parentage of the child. Thank you.
Yeah, thank you, Geraldine. So I don't want to get too far ahead of ourselves. I know that you and Mark are going to be talking about some of the existing, the paternity laws. So I assume you kind of gave us a preview about what you're going to be talking about.
Yes.
But does anyone else have questions or comments for Geraldine? All right, hearing none. Brandon, is there any member of the public who is raising their hand and wants to provide testimony at this point?
No, Chair.
All right, thank you. And ma'am, I assume you don't want to, this is one of the items you wanted to talk about. All right, so can is there any motion to have Ms. Hasegawa admitted as a member of the task force?
So moved.
All right.
I'll second.
Okay, and can we take a vote? All those in favor, please raise their hand.
Can I now vote?
Yes, you can vote now.
Your first vote.
Okay, so that appears to be an unanimous. All right, so Ms. Hasegawa, you are now a member of the task force. And since you're appearing by Zoom, well, can you just confirm that there's no one else in the room with you.
Oh, I do apologize. There is no one else in this room other than myself.
Thank you very much. All right, our next prospective member is Mihoko Ito. She's counsel of with Ashford and Riston. Mihoko, could you please introduce yourself?
Sure. Thank you, Lauren, and good morning, everybody. I'm Mihoko Ito. I'm an attorney at Ashford and Riston and also managing director of a government relations firm called Sanhai Government Strategies. In my years as an attorney, I've also been serving as a past president and current board member of the Hawaii Women Lawyers. And we've been really an active participant in commenting on and supporting, updating Hawaii's laws, parentage laws. And also on a personal note, I did have twins through surrogacy in 2017. And when we realized that we had to go through the surrogacy process, I did research the laws here and realized that there were a lot of gaps with respect to the laws here compared to other jurisdictions. So I did my research and ultimately opted to go through the surrogacy in California and had a support network there. So I feel like what I bring to the table is at least I've done a comprehensive review of the various surrogacy laws in the different states and went through that analysis and made the tough decision to have to do this elsewhere, similar to others on this in this meeting. So I think with that, it's good to see the folks. I guess I should mention also that I did serve on the prior task force, and look forward to working with everybody on crafting a law that is fully inclusive and takes care of all the issues that other folks have been mentioning. So thank you very much.
Great. Thank you, Mihoko. Does any member of the task force have any comments or questions for Mihoko? All right, seeing nothing. Brandon, I assume there's no member of the public who wants to testify on this?
Right. No one there.
Thank you. Can I have a motion to admit Mihoko as a member of the task force?
So moved. This is Lauren, Department of Health.
All right, thank you. That's enough for a motion and a second. All right, let's take a vote. Everyone in favor of admitting Mihoko, please raise their hand. I think that's 4, 5, 6, 7, 8, 9, 10, 11. All right, so that is enough to admit Mihoko as a member. All right, thank you, Mihoko. And for the record, are you by yourself in the room on Zoom?
I am actually not by myself. My kids are both homesick. Under 18, so
Nice,
if you hear singing in the background, it's them.
All right. Thank you very much.
Thank you.
Great. And our next and final prospective member is Deirdre Marie Iha. She's a partner at Goodsell Anderson Quinn and Stifel. And Deirdre and I used to actually, my office was actually next door to hers back when I was at that firm. So Deirdre, can you please introduce yourself?
Yes, thank you. Good morning, everyone. I'm happy to see such an incredible group of people together. I am currently a partner at Goodsell where I do appeals and complex civil litigation. But the reason that I was asked to serve on this committee is because before I was at Goodsell, I was at the State Attorney General's office for 14 years, where far and away the most important thing I did was work on marriage equality. I was one of 4 attorneys at the AG's office who took the lead on drafting the bill that became Act 1 that year, 10 years ago, when we finally succeeded at it. Another one of those members is now the State Attorney General, Ann Lopez. And then some of my former colleagues are still at the AG's office. James Walther and Jill Nagamine are still there. I was thrilled to hear about this effort being undertaken. The holes in the law were glaringly obvious 10 years ago, and I'm sure are only worse now with the advancement of technology since. So that's the experience that I bring to it. In addition to the legislative experience with the Marriage Equality Act, I have extensive experience with other legislation in terms of drafting and the great challenge that it takes to take policy and make it law. So I've been involved with that. So that's my background. Before Marriage Equality Act, I did also work on the civil unions bill before marriage equality, and I also was the lead attorney to defend the Marriage Equality Act when it was challenged after it was enacted. One of my proudest moments. So I'm thrilled to have the chance to serve on this committee, and that's the background that brought me here.
Great. Thank you, Deirdre. Is there any questions or comments for Deirdre from the task force? All right, seeing nothing. Are there any members of the public who wanted to testify on this item?
No, Chair.
All right, thank you. All right, so is there a motion to admit Deirdre as a member of the task force?
So moved.
Second.
All right. All right, so let's take a vote. All those in favor of admitting Deirdre as a member, please raise their hands. 2, 3, 4, 5, 6, 7, 8, 9. Right. That appears to be unanimous. So let's have Deirdre added as a member of the task force. Thank you, Deirdre. Okay, so now we're going to move on to the non-action items. These are the D items. And our first one is D1, a briefing on the work of the previous task force created by Act 201 of 2021 and the status of draft proposed statutory amendments by Judge Hall. Judge Hall, would you like to summarize the work of the previous task force for us?
Yes, and I'll give a little bit of history on the Uniform Parentage Act. Hawaii adopted the first version of the UPA in 1973, but that was created in 1973, I should say. In 1996, we updated our statute to include expedited paternity process. Although there was a proposed new UPA that was created by the Uniform Laws Committee in 2002, we did not adopt that. We still have the original version from 1973. In 2020, I prepared a draft based on the 2017 proposed UPA and started circulating it amongst other agencies, including CSCA, the AG's office, and the Family Law Section, which is a group of family law attorneys, practitioners. In 2021 legislative session, there were actually 2 bills regarding this issue. One was was based on a draft I had created, but it was not what I did not introduce it. Don't recall who did. The other one primarily dealt with just making the terms in our current statute more gender neutral. And from that, Act 201 was created and created a task force to encourage further discussion in hopes of creating a proposal with input from all who are interested. As Lauren Kim had mentioned, that Act 201 task force, we were able to meet 2 times. Unfortunately, he was extremely busy, as well as the rest of the Department of Health, with the ongoing COVID issues at that time, as well as the Red Hill water crisis that was just boiling up. So we weren't able to get very far, but a report was generated and submitted to the legislature that provided the positions of the various members that were on the task force at that time. There was no unified recommendation or proposed legislation that was presented to the legislature. The current draft that created this task force was introduced in the 2023 legislative session by the judiciary. It's different from the version that was proposed in 2021, as it does not include the surrogacy or assisted reproduction provisions. In part because there was a lot of discussion that still had not occurred. So I actually made the decision to have it removed to see if we could get the rest of the UPA to update our statute at least. I do want everybody to know that the Uniforms Law Commission currently has a working group that is discussing the issue of gamete identity disclosure, which as they progress with the information and they create a report, it may create changes that we have to consider if we are going to look at including the surrogacy and assisted reproduction provisions, which as a judge, I'll be honest, I would prefer that we have a statute that we can follow and laws that we can hold people to on what we do with surrogacy and assisted reproduction, because we essentially have nothing at this time. One issue that did come up during Act 201, as well as during this past legislative session, is the issue of whose name goes on a birth certificate. By statute, whether it be right or wrong, a birth certificate is a legal document that does not necessarily reflect biological connections. Currently, the way our statute works, the names put on a birth certificate is the woman who gave birth to the child. That may or may not be the biological mother. So if it's a surrogate, it would be the surrogate's name, whether her gamete or not were used. If she's married, if the surrogate is married, or if the person giving birth is married, her spouse's name will be placed on the birth certificate, whether or not they are the actual biological parent of the child. And also with, since the adoption of same-sex marriages, it's whether the spouse is male or female, the name will be placed on. If the birthing parent is not married, there is a method in which currently our law only allows for a male to sign a voluntary establishment of paternity that can be done either at the hospital or through the Department of Health, that they are stipulating that the male is the father of the child. If they do not have that voluntary establishment and they are not married, then the only way to be placed on the birth certificate is by court order. And that is a determination made either by genetic testing or again by stipulation of the parties. After an adoption also, a birth certificate will be modified and a new certificate will be issued that will have the adoptive parents' names listed as the parents on the birth certificate. There have been rare child welfare cases in which we've actually had to establish a mother as the parent, but those are very, very far and few between, unfortunately, and they tend to be primarily in child welfare cases. So that's a little history of the UPA itself, as well as the Act 201 task force and what has led us to our task force today.
Great. Thank you, Judge Hall. I have, let me see, I think I had a question. So, sorry, could you give a little bit more detail on what the latest version of the bill includes and maybe what it doesn't have yet?
So essentially all that was removed was the surrogacy and assisted reproduction sections. It is, the current version of the bill was modified from the proposed UPA to include suggestions that were provided by the AG's office. Jill Hasegawa had assisted with that. Not Hasegawa, sorry, Jill Nagamine. Sorry, Jerry. Jill Nagamine had assisted with that. I'm sure she was working with many others in preparing the proposals that she provided. Most of the proposals of the AG's office were included in this draft, which were not included in the draft that was part of the Act 201 2021 proposal.
All right, but there is language about surrogacy and assisted reproductive sections. It was just in a previous draft of the bill?
It was in a draft that was submitted to the legislature in 2021.
Okay. And then, So you're saying that the Uniform Law Working Group, what was the topic that they were working on right now?
Gamete identity disclosure. And, essentially creating laws on what information needs to be disclosed in surrogacy or assisted reproduction situations. Like Laurel had mentioned, I'm sure it'll include medical information, if there's access to any identifying information to a possible gamete donor.
Okay. What would the jurisdiction of that law be? I assume it would just apply to people who have, and I'm sorry, I don't know like medical terminology of this, but the people who would, I guess, have those types of procedures done in Hawaii, right? It wouldn't apply to obviously people who come back to Hawaii to have their child, but maybe have, used a fertility procedure elsewhere. Is that right?
That is something that any proposed language that we create will have to specify.
Right.
If it's a situation that the child's only born here, or if it's a situation where the child's born here, or the assisted reproduction surrogacy actually occurred here.
And then, so what is sorry, just for the record, what the Uniform Law Working Group, can you kind of give some description on what that is?
So there is a Uniform Laws Commission. They create, it's a national commission, and they create proposed laws in various areas. They are the ones that created the initial Uniform Parentage Act, as well as continuing to convene to update that act. They do guardianship laws, the whole gamut. I am not a member of the Uniform Laws Commission. We do have statewide representatives that are on the commission, including Elizabeth Kent. She is one of our Uniform Laws commissioners, and she is also on the subcommittee regarding the gamete identity disclosure.
Okay, thank you. Does anyone else have any questions or comments for Judge Hall? Any member of the task force?
No.
No?
I do.
Oh, yes. All right. Sean, please go ahead.
Yeah, I think you mentioned in general terms why the surrogacy sections were taken out. Could you elaborate a little bit? Is there sort of a dependency on the Uniform Law Commission's discussions around gamete disclosures, or is it like just politically not sort of the direction folks want to go right now? Or?
No, actually the subcommittee on the gamete donor actually I think just started this summer, so it's brand new. So they'll probably be working for some time. I would expect maybe a year or more before we get any more information from them. The surrogacy and assisted reproduction sections were removed because I knew from the Act 201 task force that there still needed to be a lot more discussion on the issue before we tried to submit it to the legislature again. So I'm hoping that we can do that here as part of this task force.
Okay, thank you.
Any other questions or comments from the task force? All right, hearing nothing, is there any member of the public who would want to testify about this item?
No, Chair.
All right, hearing nothing, let's thank you, Judge Hall, and let's move on to our next informational briefing, which is from Mark and Geraldine, and this will be a briefing on the existing paternity laws and the role of their office in enforcing those laws and carrying them out. So I'll turn it over to Mark and Geraldine.
Okay, thank you. Yeah, so we had received an email from you asking that we talk a little bit about what CSCA does, why paternity establishments are important, and then provide some comments about proposed parentage changes to the parentage laws. So just really briefly, just a little bit about CSCA. The primary goal of our agency is to ensure that Hawaii's keiki have ongoing financial and medical support from not just one parent, but both parents. In order to achieve that, CSEA primarily provides 3 services. And we've already kind of discussed that. We establish paternity through the judicial process. We establish child support and medical support, either judicially through the courts or administratively. And then we also track and disperse child support that comes in. We're in essence kind of bookkeepers for that. And then lastly, we're involved in enforcing child support. We use tools such as garnishments and liens in order to go after non-custodial parents who are behind in their child support payments. With regards to paternity establishments, like what are the benefits of those? Again, it's the legal means to allow us to move forward once we establish paternity, to establish child support. It helps to provide better stability for families. It encourages the second parent to be more involved, allows kids to have access to medical histories in the future down the road from both sides. And then it also helps in some instances children to qualify for benefits that they wouldn't otherwise have if the father wasn't established, such as for military parents, they may get health insurance benefits. Down the road, it could be Social Security benefits, inheritance, veteran benefits. So those are just some of the benefits to establishing paternity. When we meet with parents who are or alleged parents who sometimes don't want to be involved, these are the discussions that we have with them to encourage them to move forward. As far as how paternity is established for kids born out of wedlock, I think Judge Hall kind of went over a little bit about the voluntary establishment of paternity process, which is basically it provides a mechanism for a quick way to establish paternity. At this point in time, as Judge Hall indicated, it's limited to establishing the father or the male with regards to the birthing parent. Really, of all the kids born out of wedlock in any given year, the majority of our paternity establishments do come through the VEP process. So it's a really important process or mechanism that we have to get these establishments, because to do it judicially, it just takes a lot more time and resources. Oftentimes, if parents don't do that at the hospital or soon after that, it's hard for our office sometimes to identify them, locate them. There's a lot more barriers with it. So really the VEP process is really important. But establishing paternity through the judicial process is also important in that we're catching those that aren't established up front. Our office receives the majority of our referrals through the Department of Human Services. So when a mother goes on TANF, which is basically welfare for their child, those cases are referred to us by the Department of Human Services, same with foster care cases. And that's how the majority of our paternity actions, that's what initiates them, and then we move forward with them. We do offer to the public, they can request our services. So they can do it on their own or with a private attorney, but they can also request our services through an application process where we will go ahead and initiate the paternity process. Once it goes to court, as Judge Hall said, what we try to do a lot of times is we're meeting with parties and seeing if we can get stipulations or agreements. If not, we rely heavily on the use of DNA testing. So that's kind of a little bit about CSEA and what we do. I know Jerry's going to speak a little bit to the last part of that. She kind of already gave a preview of some of that, but I don't know, Jerry, did you want to go back into any of that?
Oh, Jerry, you're
You're
muted.
muted.
Thank you, Mark. Yes, I wanted to expand more on the area of the expedited process of paternity. The whole concept of paternity establishment is to, and the desire of Congress is to establish paternity, this relationship between the child and the father, as there were so many cases where paternity was a problem in the past. And through legislation, the PORA Act of 1996, the states were required to develop this expedited process of paternity. Now, this goes outside the court system. It's more like an administrative system, whereby in Hawaii, if a child is born, let's say with the assistance of a midwife, with a midwives alliance, at a birthing hospital, birthing center, or later on, if its paternity is not established with these two entities, that then the Department of Health offers this expedited process of paternity. And when it was started, that is effective July 1st, 1999 is when we had all our procedures in place. We had the forms, and we were ready to go. So therefore, we used July 1st, 1999 as a start date of this program. And any child who is who has paternity addressed through this process, it constitutes a legal finding of paternity. Whereas before, prior to this time, if the parents signed the declaration of paternity by parents, that constituted a presumption, and it was a rebuttable presumption. So it was really important that this program be offered as an alternative to the judicial process. Currently, over 90% of the paternity established in the state of Hawaii is through this expedited process of paternity. So the goal and the desire is to keep this process simple and to avoid complications and also avoid a judicial proceeding. For this reason, we are proposing that it's very important that one of the signatories on the VEP form be the birthing mother who wants to be listed on the newborn's certificate of live birth. We would then at least open the option of to be considered where, as long as you have the birthing mother as one of the signatories, the other signatory could be the biological father, or possibly it could be another female. These are topics that we can address, but keep in mind that because we are dependent, the state of Hawaii is dependent, a child support enforcement agency is dependent on having, excuse me, as high a number of paternity establishment in order to meet certain federal performance measures. The impact of not meeting this federal requirement is a cut in our EFDC budget. That is Department of Human Services, EFDC budget would be cut if there is non-compliance. So we are striving, as far as the Child Support Enforcement Agency, to continue to meet this federal level of performance. And I'd say that we are focused right now on, as far as this program, of making it easier, making it for the Department of Health, for the medical centers and the midwives, creating an online process whereby the parents would at the hospital, with the birthing center, at the Department of Health, could use this process, which would expedite the procedure that we have in place. It would also help with the storage of documents. And I think Lauren Kim can also chime in on that there is a problem with storage. So this is a current project that we are hoping could be completed and in place by 2024. With regard to the other issues, the issue of establishment of parentage in the judicial proceeding, we have found that there are issues of service that are raised, and we would like to have that clarified. Also, personal jurisdiction be expanded to include the long-arm jurisdiction. And that would be outlined in the UISA, Uniform Interstate Family Support Act, and that would be currently Section 576B 201. The 2017 UPA, Uniform Parentage Act, does recognize the long-arm jurisdictions outlined in the UISA laws, and we would like to have that incorporated in the current proposed bill. With regarding to genetic testing, there have been questions raised that why do we have to collect the racial backgrounds of the parties? That is a component of the calculations in determining the probability of paternity. There are certain races with a preponderance of DNA, certain DNAs in that population, and that is considered in terms of the genetic testing results. So we are saying that the complete language in the 2000 version of the Uniform Parentage Act with regard to genetic testing be included in the proposed bill. And lastly, regarding the creation of multiple parents and establishing parentage, currently in the state of Hawaii, there are two parents. It's either through the VEP program, either through the judicial process and establishing paternity, or either through adoption. If this committee wants to address having three persons on this for the parentage of the child, we present that it should be limited to the situation where you have two alleged fathers who are identical twins. As I stated earlier, that is one area, even with DNA testing, that it has been very difficult to distinguish between identical twins. That is, children of identical twins with the same mother. According to Dr. George Maha, they did have a case that was worked on. Unfortunately, the cost in trying to distinguish between the two alleged fathers, the cost was $100,000. And I don't think in the state of Hawaii we have the agency, which is basically the agency that people look to utilizing genetic testing, has that kind of funds for any one case. But thank you. I think that, you know, we have other concerns, but I think those are the main concerns. Thank you.
Great. Thank you, Geraldine. I had a couple questions. Okay, so I think you kind of answered my questions about like what your concerns might be for the topics that this task force is going to consider. But I wanted to ask, are you guys like a record keeping agency too? I mean,
Record keeping in
yeah.
what sense?
Yeah, so I mean, once your case is complete and you've adjudicated paternity or have it voluntarily established, who keeps the records of that determination? Is it your agency or is it Department of Health or the Department of Health?
Oh, every paternity establishment that is done judicially is sent to the Department of Health. The Department of Health also is the receiver of the voluntary establishment of paternity forms, the expedited process of paternity forms from the various birthing centers, the hospitals, and the midwives. So the birth certificate reflects the result of this paternity establishment. This is a situation where the parents are not married to each other, but alternative methods of parentage are being utilized, but kept by the Department of Health as far as what is reflected on their birth certificates. As to the Child Support Enforcement Agency, any case that is utilized by the agency, that is processed by the agency, and that is the judicial establishments, the agency does keep a record.
Can I ask a question on that?
Yeah.
Judge Paul, I wanted to ask you actually, because that makes me think of something. When we do an establishment of parentage, for instance, in connection with a surrogacy case, and when we do one that involves a non-genetic parent, so there's also an adoption. Through the adoption process, a certificate of adoption gets automatically sent by the court to the Department of Health, which I've always interpreted as being kind of the way of making sure nobody tampers with it, right? The judge signs it, it goes straight to the Department of Health. But I believe our clients typically have to submit the judgment of parentage to the Department of Health themselves. And it's supposed to be certified and they attach it and stuff. But it might be something for this committee to consider, unless your experience is different, why there isn't an automatic document sent from the court to the Department of Health for judgments of parentage as well. Have you ever seen that happen as an automatic part of the process, the way it does for adoptions?
So no, the judiciary does not send anything to the Department of Health with regards to paternity cases.
Yeah, that's kind of an interesting difference.
And the ones that need to be sent to the Department of Health themselves is those that are privately done. If Child Support Enforcement Agency is the petitioner in the determination of parentage, then they usually send it to the Department of Health for the parties.
Thank you.
Can I ask a question?
Yes, please go ahead.
This is Jeff Esmond for Geraldine. I just have a personal interest or curiosity in what you were talking about. I'm an identical twin. My twin brother also has kids by surrogacy. In fact, we both have twins by surrogacy, Borgel twins. But I've never actually heard of the issue you're talking about, and it seems like such a rare type of situation when there's so many different varieties of situations that can come up in terms of parentage. So I'm not clear why this is a priority for discussion for the task force.
I believe the concern was in the proposed 2017 Uniform Parentage Act. There was some discussion about creating responsibilities for more than 2 parents. And that is why it was raised. We have not had that problem. In fact, in the state of Hawaii, since I've been involved with the Child Support Enforcement Agency and paternity established, I don't recall a situation where we have had identical twins being alleged fathers. We have had brothers, but that has been through genetic testing. It can be distinguished as to those 2 persons. But it is rare. It is a rare situation.
So the topic of the multiple parents, which is an interesting topic, you're suggesting that it must be addressed by incorporating the identical twin type of situation.
It must be addressed, pardon?
The identical twin situation must be addressed as part of the multiple parent issue as a whole. Is that what you're suggesting?
Yes, it should be. And I believe that Mark Nugent, he and I were discussing the situation. He had a situation not involving the exact scenario, the factors, but we do come across cases that are not typical. And these are addressed judicially. And Mark, did you want to talk about your situation?
I think I would just want to say that I think the issue is whether there should be multiple parents allowed on the birth certificate or whether it should be limited to 2. The whole issue of identical twins, I would agree, Jeff. It's that that's I haven't ever seen it happen, and it's highly unlikely that'll come up. So I think that's more of a just a very side topic as an example of an exception. But I think that the issue the bigger issue that would be for discussion would be, should it be limited to 2 parents, or should that be extended out to 3, or I don't know, possibly more? Because I do understand that, you do have sometimes cases with parents with competing presumptions, and you may have 2 fathers and a mother, or whatever the combination is, where you have 3 parents all wanting to be involved. So I think that's the bigger question that this committee would have to address. And I think our concern with that is more about the impact if we add 3 with our systems of how they're set up. With CSEA, we're not set up to track child support for 2 non-custodial parents, or the Department of Health, I don't believe at this point in time, is set up to add a 3rd parent to a birth certificate. So I think that's the bigger issue that would be up for discussion with this committee when that comes up. So yeah.
Thank you.
Thank you.
So I see that Judge Hall has her hand raised, and also Deirdre. So Judge Hall, I think your hand was up first. Do you want to chime in?
Yes, please. I just want to clarify the 3 more than 2 parents provision. The idea my understanding of the idea of it being included in the UPA was more of a kind of a twofold. There's the LGBTQ community that could use it, where you could have the mom who gave birth, the birthing mother, but also still allow for like 2 same-sex dads. And then you could have 3 parents on the birth certificate because they all want to be part of the child's life. And this goes back to, again, the birth certificate being a legal document versus a biological document. Another situation it can be used is when you have mom, biological dad who comes into the picture way down the road, but in the meantime, you had this de facto dad, the dad who raised the child from a young age, and the child recognizes as their parent. Sadly, we do have that situation come up, not a lot, but often enough that with the current law, we have to choose between the biological, in the best interest of the child, who's best to be the parent, the biological dad who has not been in the child's life for whatever reason, and the de facto dad who's raised this child and the child recognizes as their father. And we have to, under the current law, we have to choose between those 2 dads to make a determination who gets to be on the birth certificate and who would have legal rights to the child. If we can have more than one, then we'd have the opportunity to have both dads and the child to have more than just 2 people that want to be in their lives.
Thank you. Deirdre, did you want to chime in too?
Actually, Judge Hall's answered my question. I was about to ask about de facto parents and knowing that, you know, the relationship on the ground for the child emotionally and in terms of financial support may not be limited to 2 people, right? So in any case, I don't think we're going to be making any decisions on this now, but basically Judge Hall answered my question indirectly. So thank you.
Thank you. All right, are there any other comments or questions about this item? Mihoko?
Yeah, this question is for Geraldine. I was just wondering if you have looked at how other jurisdictions have handled updates to the administrative procedures. I would imagine that, you know, it's not the first time it's been looked at, given that it's a federal law that's been implemented in all the states, right? So as states have updated their laws to sort of reflect a procedure that matches the updates to the judicial proceedings, I'm just curious if you've looked at that.
Hi, Mihoko.
Hi.
Hi. No, I have not recently looked at it. I've talked to other states. The states basically that we have seen in terms of the intergovernmental cases between states, and I have seen the birth certificates. It's generally been where you have 2 parents on the birth certificate. As far as the process, because of the 1996 law, and it's a federal law that all the states had to comply with in order to receive federal funding under this program to the child support enforcement offices. We all follow the federal requirements in terms of how we establish the information provided to the parents. We do allow for a rescission, and that is pursuant to statute as guided by the federal laws. It's pretty much uniform in terms of what other states do. Now, the difference is some states like Florida have a modified online program, but not fully. And I think that is where the states may be headed towards, that is to have it an online program. Online, that is between the birthing institution, the midwife, and the Department of Health.
Question? Jerry?
Yes.
Hi, Jerry, Carol Lockwood. I have a question. You know, when we do a gestational surrogacy, we typically instruct the gestational carrier not to list her husband on the birth certificate forms of the hospital, because we know that even though he's going to be the presumed father by law, we know that that would essentially be making a false statement. She knows he's not the genetic father. She knows exactly what the origin of the embryo was. Are you saying that each time we do that, it has an impact on federal funding?
Wait, just a moment. I can't hear you very well.
Sorry.
Can you come closer?
Yeah, can you hear me better? If I come closer?
Yes, yes.
Okay. So when you mentioned federal funding, when we do a gestational surrogacy, we instruct the surrogate typically not to put her husband on the birth certificate forms of the hospital, because even though we know he'll be the presumed second parent of the child by law, we know also that she knows he's not the genetic parent, and therefore she'd essentially be making a false statement on the form. And so we just get an incomplete registration birth certificate with just her name on it, and we don't worry about it because we're going to court anyway to establish the legal parentage. But are you saying each time we do that, it affects the state's federal funding because we are listing the mother without the genetic father on there?
Excuse me, but on the surrogacy, are you subsequently doing an adoption? Is that it?
We do a subsequent parentage if it's a genetic parent, and we do a second parent adoption if it's not a genetic parent. So we do eventually go to court. Does that stop it from affecting the funding? As long as it's established.
Not if you do the adoption. It's
okay.
The federal government will accept not only the parentage, that is establishment of paternity through the VEP program or the judicial program, but also the adoption.
Oh, good.
It creates a responsibility as to the parents as to that child. So
okay.
Yes.
I was afraid that just by doing that temporarily, we were messing with your funding.
Not unless your adoption takes a long, lengthy time, because we must have the stats within the federal fiscal year. That is from October 1st of each year to September 30th. But if you can meet those kinds of requirements, that would be good. Thank you.
All right, thanks. We'll keep that in mind.
Does anyone else have any comments or questions for either Geraldine or Mark? No? All right, is there a member of the public who wants to provide comments on this item?
Two?
No?
Three, yes.
Okay.
All right, Brandon,
No, Chair.
Okay, thank you. Okay, so let's move on then to the next item, which is a discussion regarding a plan for our work, including a discussion of issues to be addressed, identification of tasks, goals, and priorities, division of work, and timeline for completion of tasks. And I realize this is very broad, and we're probably not going to get to it all today, but I wanted to, have a broad topic so that we can, have the freedom to discuss the next steps, like our first steps actually, and maybe at least a plan of how to move forward, and hopefully a plan for what we can do at our next meeting too. So
do we know how often we'll be meeting? Sorry.
Oh no, so we don't know how often we'll be meeting, and we can talk about that too. And other topics I think we could discuss for people who have been on the previous task force. I think that you guys created permitted interaction groups, or PIGs as they're sometimes called, and that allows like a smaller group of members to meet outside of a sunshine meeting, as long as they have a specific task and they report back on their findings to the group later in sunshine. So that's another tool that we can use to make ourselves more efficient. And we can also talk about whether there are any other groups or members that we think we should either have come to talk to the task force, or that we might want to invite to join. I know Judge Hall mentioned the Uniform Law Working Group. That's an example of maybe some some group that we want to have involved. So yeah, it's kind of broad, but does anyone want to start off the
So
discussion?
Lauren, I'll start because I did
Sure.
my homework and I made a list. So
Okay.
because I'm advocating for us looking first at local laws, and I'm sorry, I counted, we have 8 lawyers, so I'm hoping this isn't too overwhelming, so that we can divide it up amongst all you lawyers, I think. I wanted to have someone look at both Act 160 and 161 that came out of this legislature, which does address and amend certain sections of law to provide gender neutral terminology. And the reason why I'm asking that is I'm wondering if it will help some of the situations we've been discussing today. And then I did want to add that the legislature did adopt the Uniform Law on Probate this year to again address some of these issues, which was a good thing. You know, that was a win. Judge Hall is correct. The Uniform Law Commission, actually their website is quite open. I found all kind of information. They do have a member only part of it, but on this particular law in particular, I think they've archived it pretty much back to the original. I could be wrong because it would be pre-technology, but I know that the 2017 debates and some of the notes are there. So for people that have extra time like me who's retired, I've been looking at that, but I found it quite helpful to look at that. The other thing I wanted to note to the group is sections 578.14 and 578.14.5. We did work on when I was advocating openness in the adoption records. And I find it interesting when you all are saying we don't allow more than 2 parents on a birth certificate, because we intentionally in 578.14 allowed for both birth parents and adoptive parents to be on a birth certificate. So I don't know if Department of Health just never has done it because there were some other problems with it, but it's there in law still. So I don't know what happened. We'd have to ask Department of Health about that. And then 78.14.5, it does allow for the collection of medical information, again, through Department of Health. And I think that's why Lauren was asking where a lot of this information is deposited. Again, I don't know. We have to ask. I don't see where Lauren had to go do, you know, some other work right now, but we might want to ask Department of Health to report back on, have they in fact been collecting this information for adoptees? I don't know. The other thing regarding the
Lauren,
hi, Lauren.
can you? I'm arriving at the Disaster Recovery Center, so we're going to set up. Can you type that question in the chat, or
Yeah.
And then I'll take it back and try to get the info.
I can't because I don't have a computer, but I'll have somebody else,
Yeah.
someone else, or we can email you, Lauren. I know how to reach you. How about
Okay,
that?
thanks.
Is that okay? Yeah. Okay. The only other things regarding this Uniform Law on Parentage, I understand that the recent amendments from 2017 on, it's a waterfall from Obergefell, which we all, I hope, agree is a good thing, but also 2 cases called Pavin. I don't know if it's Pavin or Pavin, and Box. And these were 2 female couples. One of the spouses was not allowed to be added to the birth certificate, but the fact situation I think is a little different than what we're dealing with, because I think 2 of these couples, they were actually, I don't know if they were divorced, but they were separated. So there was an issue of custody as well as birth certificates. So, but my understanding, the reason I'm raising it is that these were some of the cases the Uniform Law Commission was using to then create the uniform law. So I don't know if we want to talk about that or not. It might be too much information, but just for people's awareness. And then I'm almost done, Lauren. The following concepts come to mind when I think about this law, and one is informed consent, because we have a child being born. Clearly, they are not capable of giving informed consent, but yet something's happening related to their life, which I think have lifelong consequences, that they're not being given, you know, an opportunity. So that's why I'm a little pedantic about this. You know, this is someone that's going to hopefully live a long time, and we're kind of cutting them off at the roots there right when they're born. The other thing that comes to mind, particularly when we're talking about medicine, is you first do no harm. And Dr. Fratarelli, you would know that better than all of us, but there's physical harm and there's emotional and mental harm. And this is the thing that we've been struggling with in the adoption community for years now. You know, a child is born and you're cutting them off from their roots. And then what happens is years later, we're dealing with the emotional and mental harm. Okay. So if we could not do this to begin with, I would hope we could address that. And the following is the legal concept of parens patriae, which is the government, as we just heard, lengthy discussions about child support, and thank God they're there. The government is ultimately responsible for taking care of children, and Judge Hall, you know, has had to deal with this day in and day out. So I'm just concerned that we don't pass a state law where the government is responsible for taking care of children, and again, we're cutting them off at the root. So those are kind of the larger issues that I'm throwing into the stew pot. And thank you all again for listening to me.
Oh, thank you very much. Yeah, so I was kind of wondering, you know, what, like, I obviously don't want to reinvent the wheel, and there's obviously been a lot of work done, I think, on Judge Hall's part, especially in revising existing laws. And so I would like to at least start with, you know, understanding of what document we should be working off of. And it seems like, and Carol, I think when you mentioned Act 160 and 161, Judge Hall, were those the acts that you mentioned earlier, that included, or were those the 2021 bills that included?
No, that's just,
Just okay.
yeah, that's just to make terminology gender neutral in the adoption statute. And I'm sorry, Laurel, I forgot what the other one was.
BEP or?
It's, parents and spouses, adoption, annulment, and divorce. And
Okay,
honestly,
okay.
I
So those are
didn't print them out, but
Narrow.
I'm just wondering, I'm asking as a layperson, I don't know if they affect what we're talking about.
I see.
I would think it might, but I don't know. So I'm asking.
I think a baseline question for us is going to be, do we agree as a group that we would like to at least set a target of trying to address everything and not excluding the surrogacy and assisted reproductive technology, since we have the time and since we're just starting out? Or are people planning on doing something more narrow than that?
Does anyone want to?
My personal preference from a judicial standpoint would be to, if we have the time, if we could discuss everything while we have everybody at the table, that would be my preference.
We have till 20.
And as somebody who's been cribbing it together for 14 years in front of Judge Hall and others, I would also prefer, you know, there's some great statutes out there, and Judge Hall has done a lot of great work. And why leave things up to the whims of individual attorneys and judges if we can, you know, take our time to chart a clear course and make it as good as we can?
Yeah. Anyone else have?
I'd like that too, folks. I think that's probably why I'm here.
Me too. I totally agree that it should be comprehensive. And I think one of the, from my perspective, and, you know, especially with sitting with the Hawaii Women Lawyers hat on, you know, that was one of our comments on the bill that was introduced. The last bill that was introduced was that it wasn't comprehensive and didn't address surrogacy. And, you know, I just think that we've got the brain trust here. We should include all the provisions and do the best we can to craft a comprehensive law.
I agree very strongly that we need to patch the holes, especially for same-sex couples who are using reproductive technology. But hypothetically, the same thing would also happen for straight couples. There's a lot of people who would be affected by this. So any case, I would like to see us do comprehensive on that. And not to say we can't address all the other issues. I do have one very basic question. Beyond the materials that Lauren had sent, which includes the most recent report from the last task force to the legislature and the materials that I can get on the Uniform Law Commission's website, people have suggestions about, you know, very pointed things that I could review, I'd appreciate it, because I know you're talking about all different potential sources of law, and I would much rather have you guys point me in the right direction than just go wandering around. For people who may not be familiar with the Uniform Laws Commission, I'll just mention it's not it's not itself a legislature. It's a private organization that's basically a think tank to propose best practices for various areas of law. They've covered laws all across every possible subject. They are very popular because they bring in all the experts, it's national. And then a lot of times what will happen is certain uniform laws are adopted by state after state after state. And the amount of information that comes out when you look into a uniform law is enormous. I've had opportunities to study other uniform laws in the past. So there isn't like some person we could talk to. If they say something, they're going to say it in writing and they'll issue a report or a proposed law or something like that. So it would definitely be worth keeping our eye on it if they're working on the gamete issue. But that's kind of the way that we would probably wait to see what they're going to do on that, or be aware that that's continuing to move. Those laws are very well respected nationally if it's a uniform law. It doesn't mean that they're literally identical in every state, because states will tweak them. And if they tweak it too much, then they don't count anymore as having adopted the uniform law. But that organization itself is not a governmental entity. It's a think tank that proposes laws for states to adopt on any subject. So I would mention that.
Yeah, thank you.
And if I can just add to that, the draft that was submitted for this 2023 legislative session did go through members of the Uniform Law Commission. They did, so a couple things. First, the draft is amended to include some of our current state laws that we have that could have been detrimental to our procedures and process if we were to remove them. We didn't want to change the system specifically for Department of Health or CSCA too dramatically. So we were trying to keep a lot of those provisions that we currently have in place. So there were those changes and the deletion of the surrogacy and assisted reproduction. They said despite that drastic change, were still recognizing it as part of the Uniform Act that was proposed. I will also throw this out there. I'm not sure quite how long it'll take me. It might take a couple weeks, but the draft that was used in 2021 that we used to discuss as part of that task force is different than the one that was done for 2023. I could try to see if I could merge the two to add back the surrogacy and assisted reproduction sections so that we have one document to work from. Because like I said, a lot of the changes for the 2023 proposed language, what came from the AG's office, and it covered concerns from Department of Health as well as CSCA.
Maybe the AG has it. Did you all have it?
Well, I think the version that we were working off of didn't have the surrogacy.
Oh, okay.
And
Unfortunately, the burden of that would fall on you, Judge Hall.
Or Judge Hall.
I might be able to get some help with that.
yeah, I think that would be great if we could, come up with like the best and latest version of the bill. And, obviously we don't have to, that's not going to be our final, our final product, but yeah, as long as we have something that we're all starting from, I think that'd be really good. And maybe from there we can discuss how to sort of divvy up the work of revising it, like maybe, by topic or by section, or, maybe just different groups look at the whole law with like an eye towards, different, making sure different interests are accounted for. So yeah, but I think maybe that's a good start that we could, ask Judge Hall, hopefully, and Judge Hall, please, let me know if you need assistance.
We can
with
help.
That. Come up with a starting document that we can all work from.
I have to double check. I just have to check the timing of when I made the requested amendments from the AG versus when I cut out the surrogacy and assisted reproduction sections. If I did it if I did the AG's amendments prior to the cutting it out, I may already have a document in
Okay,
place.
great.
So I just need to check on that.
I have
so-
one super quick question. Judge Hall, when you said there was a 2023 draft, that means it was working with this previous task force or with stakeholders, or was there a piece of legislation?
It was legislation. that was
Legislation.
submitted
What-
in the judiciary package. It was, is it SB or HB?
I think it was HB 384.
Thank you.
Okay, thank you. Okay.
It was introduced. or not? You just get it off the legislature's website.
Yeah,
Yeah.
you can look at it on the legislative
Yeah.
website.
I mean, it includes the.
Well, she doesn't know if it included, she
Yeah.
has,
Oh,
Judge
oh,
Hall
oh,
reviewed to see
oh,
whether
oh,
she
got
incorporated
it.
the comments
Okay.
before or after.
Okay.
Yeah, so we might have to have like kind of a little bit of a Frankenstein document. But
Oh.
if there is one
Just a
that
starting
already
place.
has, that already has everything we want to start looking at, then that would be ideal.
Should that be our next action item then to obviously give Judge Hall as much help and time as she needs to do that, but then use reviewing that as our
Right,
primary
yeah.
action item?
Yeah, and I don't think it needs to be in action. I think she could, we don't
No,
have.
no, I
to-
didn't mean for her, but I meant for
Right.
us to review it.
Oh, yeah, for us
as
to
members
review
of the
it.
committee.
Yeah, I think that can be it. And
I'm not giving action items to judges.
I mean, we just owe an interim report this year, correct?
Yeah, so our
So,
interim report,
Maybe we
we'll
shouldn't
we'll
get too
summarize.
stressed out yet.
Yeah, we'll summarize, how often we've met and what we've looked at, but
Right.
we're not, I think if it turns out that we're not able to, give the legislature a draft by this year, I think we,
It seems
we've
like
done our best.
It seems like reviewing the draft bill will help identify kind of the primary topic areas that are gonna have discussion and those
Yeah.
that might have points of disagreement and things like that, and it might help inform what committees, subcommittees, or whatever we need,
Yeah, so,
or pigs. sorry,
right.
Pigs.
So I don't think we're ready at this point to even like say what types of pigs should be formed unless anyone has an idea of something that they know that, we should already know that we're going to be utilizing.
I think we should look at the structure of the bill, the most recent bill, and whatever Judge Hall can give us that is the more inclusive document.
Okay.
Agreed.
And to let the structure of that organize us, right? Because the goal is a piece of legislation. So
Awesome.
I suspect we'll all identify different points that will become kind of our discussion topics.
Yeah. Okay, so that will be an item for our next agenda. And I guess Judge Hall, how much time you need would help us. That would affect when we want to meet next. So do you think like would a month from now be okay, or do you think?
Oh,
you
no,
need-
I'll have it done before then. I'm just looking at it right now. It looks like I may have something actually ready to go out. Because I got the amendments from the AGs on August 26, 2022, and my last draft with the assisted reproduction and surrogacy sections I did in October of 2022. So
Nice.
it looks like I might already have something in place.
All right, awesome. Yeah, so maybe we can meet even sooner if everyone's schedules work out. Does anyone have an idea of how often they'd like to meet going forward? I mean, I would propose at least once a month.
if we're imagining I always think this acronym is so funny, the PIG groups, then in my opinion, this full committee should meet no more frequently than once a month, because we're each going to be committed to one or multiple smaller groups that'll be addressing subjects.
Yeah.
So that's what I would suggest. Because I'm assuming what we will hopefully wind up doing by the time of our next meeting is be able to divvy up topics and then divvy up who's going to look at them, and then be, coming up with, analysis of the relevant portions of the bill to report back to the larger group, right?
That sounds like a good idea.
Yeah.
Does anyone else have like ideas or suggestions for, considering other people or groups we should ask to join? It sounds like with respect to the uniform laws group, as long as we kind of keep ourselves up to date on what they're doing, maybe we don't actually need them, to have a member join us. But if anyone, has another idea or some other suggestion, we're happy to hear it.
I would,
Oh, sorry, go ahead, Mikey. Go.
oh, thank you. Thank you, Judge. No, I would just say that with respect to the uniform law group, I don't know that they necessarily need to be added as a member, but at some point it would be good to consult with them. Just because, if we all have the goal in mind of actually passing a law, they do come in and testify on bills, especially when they feel like it's departed too far from the uniform law models. So I would just mention that as a suggestion at some point.
And actually, I was gonna say something to that. I did reach out to Elizabeth Kent to see if anybody would be interested. And she said they prefer to just be available for questions and consultation if necessary.
Okay. That sounds good. Does anyone else on the task force have any other comments or questions before I ask for public testimony on this? No? Okay, so I'll ask if there's any public testimony on this item, either on Zoom or in person. All right, ma'am, can you please, you can give us your name for the record, and again, I ask that testimony be kept to 3 minutes, so I'll keep track of time for you. Thank you.
Aloha and mahalo. My name is P.M. Mazinga. In my humble opinion, I think we should all disavow the notion that mommies can be great daddies, just as we should disavow the popular opinion that daddies can make great mommies. They can't. The two sexes are different and different in core, yet critically necessarily in the socially, culturally, and biological development to a viable human being. Paternity is a legal fatherhood which affords you the responsibility of providing for your child protection emotionally, physically, and financially. My concerns are varied in light of our current events. Whether a paternity-based father who has an underage daughter on his health insurance can prohibit his daughter from having an abortion. Whether a paternity-based father can require notification when his daughter has a schedule of an abortion. Whether a paternity-based father can be informed whether either of his children are prescribed sex-altering or growth-prohibiting medication. Whether a paternity-based father can be informed when either of his children exhibit drastic behavioral changes, the use of pronouns, or school change clothes projects. Whether a paternity-based father arranges to or can be informed of any sex alternative or alternating or sex mutilation surgeries that his or her child is about to receive. How can we guard our children if access to information that directly impacts their health and well-being aren't written into law and aren't at our disposal? I'm sure all would agree that parenting ain't for wimps, neither is fatherhood.
Thank you. Thank you for your comments. Brandon, are there any other members of the public who have asked to testify on this item?
No, Chair.
All right, thank you. All right, so that's gonna wrap it up. It sounds like we will be hearing from Judge Hall, and I think once I get that, I'll reach out and ask for people's availability for the next meeting, but I want to make sure that we have a document and some time to review it before we meet again. So, all right, thank you everyone, and that will adjourn, or I'm sorry, Judge Hall, do you want to make a comment?
Just real question, when I do have it ready to send out, do I use one of the emails you use, or do I just send it to you and you'll send it out? How do you, I don't want to violate any of the
Yeah,
rules.
you can just send it to me and
Okay.
and I'll figure it out from there.
All right, thank you.
All right, any other questions from the task force? No? All right, well, thank you everyone so much for joining us today, and we went a little bit over 2 hours, but you know, hopefully.
Thank you to Lauren.
Yeah, thank you, everybody.
Great, thank you.
Thank you.
Thank you.
Bye.
You.